Hello and welcome everyone to the current affairs series. The first news is about spice to boost small and large cardamom. Farming Spice Board scheme is meant to expand the area under cardamom and increase productivity of small and large cardamom, generating surplus for export of quality spices through post-harvest improvement. This means that recently the Union Ministry of Commerce and Industry has approved a spice board scheme, sustainability in the spice sector through the progressive, innovative and collaborative intervention for export development. A spice scheme aim to significantly enhance the export of spice and value add the spice product, as well as improving the productivity of cardamoms, upgrading the post harvest quality of spices across India for export. It is implemented during the remaining term of 15th Finance Commission up to 2025 to 2026. Key highlights of this scheme is that it is expected to facilitate value addition and to drive innovation and sustainability in the spice sector by introducing new sub-components program like Mission Value Addition, Mission Clean and Safe Spices, promotion of GI spices, support for entrepreneurship through Spice Incubation Center, etc. The scheme gives thrust on farmer groups FPOS, farmer cluster identified under the ODOP and DEH SC/ST community, exporter from Northeast region and SMEs. While exporter with the valid certification of registration as exporter of spices are eligible for assistance under these program, preference will be given to the first time applicants as small and medium enterprises, etc. The program under this component, such as improving the productivity of cardamom and post harvest quality upgradation of spices, are specifically designed to empower farmer group including farmer producer organization FPOs, farmer producer company FPCs, self-help group SHGs in key spice growing region. These groups will be prioritized for post-harvesting improvement of spices with the target assistance provided to enhance creation of an exportable surplus of spices in compliance with the applicable food safety and quality standard. Scheme activities will be geotagged and fund availability, status of application under different component, list of beneficiary, etc. will be published in the board website for better transparency. So this is about the first news. Second news is about National Consumer Dispute Redressal Commission. Recently, the National Consumer Dispute Redressal Commission declined to give State Bank of India more time to take submission on its plea seek transfer outside Tamil Nadu of a consumer complaint filed against it by Madras High Court judge. About this commission, National Consumer Dispute Redressal Commission, it is basically a quasi-judicial commission set up in 1988 under Consumer Protection Act of 1986. Mandate is that it helps to provide the inexpensive, speedy and summary redressal of the consumer disputes. Here the particular redressal is for consumer disputes, which is headed by the sitting or a retired judge of SC or sitting or a retired Chief Justice of High Court. NCDRC shall have jurisdiction to entertain a complaint value more than 2 crores and also have appellate and revisional jurisdiction from orders of state commissions or the district for a case which may be over there. The provision of this act cover good as well as service goods as well as services. Who can file a complaint? A complaint may be filed by the following, like any voluntary consumer association registered under Companies Act 1956, the central government or state government, one or more consumer where there are numerous consumers. Appeal can be any person aggrieved by an order of National Consumer Dispute Redressal Commission may prefer an appeal against such an order to SC when a period of 30 days. Okay, so this is about the news. Okay, now next is about AFSPA, means Armed Force Special Power Act 1958. Okay, the center and the Manipur government are set to review the scope of Armed Force Special Powers Act in the northeastern state. About this is that it is a law enacted by Parliament in 1958 which gives the armed force special power and immunity to maintain the public order in distributed area when it is applied. Okay, it can be applied only after an area has been declared disturbed under section 2 of the act. What is a disturbed area? A disturbed area, okay, can be considered to be area. Okay, first of all, an area can be considered to be disturbed due to the differences or the dispute among the different religious, racial, language or regional group or caste or communities. Who declares an area that is disturbed? The central government, the governor of the state or the administrator of the union territories can declare the whole or the part of the states or union territory as disturbed area. It can invoke in the places where the use of armed force in aid of civil power is necessary. The special power of armed force under the AFSPA, that is AFSPA, are that they have authority to prohibit a gathering of 5 or more person in area, can use force or even open fire after giving due warning if they based on if they feel a person is in contravention of the law. If reasonable suspicions exist over that person, the army can also arrest the person without a warrant or enter or search premises without a warrant and ban possession of firearms. Any person arrested or taken into the custody may be handed over to officer in charge of the nearest police station along with the report detailing the circumstance that led to the arrest. These armed forces are immune from prosecution unless the union government provides sanction to the prosecuting agency. Where AFSPA is in force now, apart from Nagaland, this Armed Force Special Power Act is currently in force in Jammu and Kashmir, Assam, Manipur, except Imphal and Arunachal Pradesh. Okay, now next is Mankidia tribes. Okay, it is like recently Mankidia tribes community became 6th particular vulnerable tribe group PVTG to get habitat rights over forest of Orissa. About this community, there is a story given about Rama Mankirtia, a resident of Khuta block in particular village of Orissa, Mayurbhanj district. Okay, this habitat, okay, the habitat rights were formally provided to this tribe on 22 September under the legal section of the Scheduled Tribes and the other traditional forest dwellers, that is Recognition of Forest Right Act 2006, a landmark legislation popularly known as Forest Right Act 2006. Okay, about Mankidia tribe, it is basically a community which is Austroasiatic community that ekes out a living mainly from the forest. They constitute a semi-nomadic section of Birhor tribe. They have been identified as particularly vulnerable tribal group in Orissa. Occupation, their primary occupation is that they gather food and hunt. They are one of the most little known forest dwelling and wandering communities of the state as well as the country. They wander inside forest in small bands and stay in different tandas, that is temporary makeshift settlement comprised of the temporary dome-shaped leaf huts. It's basically a jhopri kind of thing, known as kumbhas. Okay. Now language they speak is that Munda language, and some of them also conversed in Odia. They believe in both malevolent and benevolent spirits of the gods. Okay, malevolent and benevolent is like malevolent, you can say that kind of god which owns some sacrifices, and benevolent is that which provides something. Okay, that is paropkar that we say. So Lagobir and Buddhimai are their supreme deities. They worship their ancestor for the purpose of enjoying health and achieving success in hunting and collecting uh, forest produce. They are mainly found in Orissa, Jharkhand, Madhya Pradesh and West Bengal. Okay. Now next is about Pact for the Future. So basically it is from United Nations Affairs. Pact for the Future, world leader plays action for peace, sustainable development. Okay, recently it is a report by UN Affair. Okay, this depicts that recently the United Nations General Assembly UNGA adopted a pact for the future, a comprehensive agreement designed to reshape the global governance for 21st century at the summit of the future. About the Pact of Future, it is a landmark declaration reaffirming the commitment of UN member states to sustainable development, peace and stronger global governance. The Pact 5 broad focus area includes sustainable development. Okay, that you can say. Sustainable development, it includes a pledge to move faster towards achieving the UN Sustainable Development Goals and Paris Agreement commitments on the climate change. It also talks about international peace security. Okay, international peace and security. In the international peace and security, redouble efforts to build and sustain peaceful, inclusive and just societies, and address the root cause of conflicts and protect all the civilians in the armed conflict. Science and technology and digital revolution. Science, technology and innovation have potential to accelerate the realization of aspiration of the United Nations across three pillars of its work. Youth and future generation, that is listen to young people and include them in decision making at national and global levels. Transforming global governance, build stronger partnership with the civil society, private sector and local regional authorities in order to be grounded in the norms and values of justice, inclusion, so that nobody feel social exclusion, like alienated. Everyone will have the equal opportunity under equity. Okay, now the next is that about the doctrine of possession. Okay, the doctrine of possession talks about, okay, it talks about that invoking the doctrine of constructive possession. Supreme Court recently ruled that watching child pornography over the internet without downloading would also amount to the possession in terms of Section 15. Section 15 of the POSCO Act provide the person had a degree of control over such material. What is the doctrine of constructive possession? It is basically, okay, it is basically legal doctrine. Okay, it is a legal doctrine that attributes the possession of an item or substance to individual even they do not have the physical control or immediate possession of it. In criminal law, constructive possession arises when a person has intent and ability to exercise control over the item or substance either individually or jointly with others. Unlike actual possession, which involves physical custody or control. Constructive possession is based on concept that an individual can still be held responsible for the items they have power to control, even if those items are not physically on their person. The key element is the intent and capability to exercise dominion or control over the object or the substance. Okay, constructive possession allows a person who does not actually have personal possession of something yet still controls it to be the charge with the crime of for possessing it. Okay, constructive possession often arises in cases involving illegal drugs, firearms, or stolen property where the defendant may not have the direct physical possession but can control and has access to the items of that. For a successful prosecution of constructive possession, certain criteria must be met. These includes knowledge of the item's presence. The individual must be aware that the item exists. Mere proximity to an item without knowledge does not constitute constructive possession. Ability to exercise control. The person must have the capability to maintain the dominion over the item. This means having power and intention to control its use. Then intent to possess, that is, there must be an intent to possess the item. This can often be inferred from the circumstance such as location of the item and the individual's